Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, as a person who has spent pretty much the last 30 years in the criminal justice system and in and out of courtrooms, typically it is the judge who hands out the FO in the FA-FO equation. Defendant FAs, goes into court, gets convicted, judge then gives the FO, and away we go. Today, we're going to tell you about a reverse equation here because we're going to talk to you about a judge who's going to get the FO. That's right. We're going to talk to you about Wisconsin Judge Hannah Dugan. Oh, she made herself famous about a month ago when she helped an undocumented or illegal alien avoid arrest in her court facility. Well, guess what? She is in a lot of trouble and she is about to have that FO moment. So today, let's spend a few minutes and let's talk about the Wisconsin judge that DOJ just indicted. Okay, America, we cover a lot of things related to the criminal justice system here at Washington Gun Law. This is a unique opportunity where we are going to talk about a judge not because of a terrible ruling or a terrible decision or anything like that they made from the bench. No, this is actually going to be because the decisions they made, partially from the bench and partially from in chambers, is such that they have now been indicted with a federal felony, actually 2 federal felonies. Meet Wisconsin Judge Hannah Dugan. Now, we've already done this video right here. In short order, what happened is a defendant appearing before the judge. It was brought to the judge's attention that there were ICE agents waiting outside. The judge ordered the ICE agents to then go speak with presiding judge, and using that opportunity with the ICE agents trying to speak to the presiding judge, then assisted the undocumented or illegal alien and their defense attorney out through chambers and out through a private exit used only by judicial staff and juries. This, of course, had federal agents completely furious, and they ultimately did arrest her. Now, we believe that she was going to be charged under 8 United States Code Section 1324, which we have talked about, because if you assist an illegal alien in any way, shape, or form, knowing that they're an illegal alien with the intent of obstructing, thwarting, hindering, or delaying any type of deportation effort, you're on the hook for a federal felony. Well, guess what? As expected, there are plenty of other laws that the judge could have been charged with, and we learned today that she has been indicted on 2 separate felonies. What are they? The first is obstruction of proceedings before departments, agencies, and committees found under 18 United States Code Section 1505. That law specifically tells us, whoever corruptly or by threats or force or by any threatening letter or communication influences, obstructs, or impedes or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States, or the due and proper exercise of the power of inquiry under which any inquiry or investigation is being had by either House or any committee of either House or any joint committee of Congress, shall be fined under this title, imprisoned not more than 5 years, or if the offense involves international or domestic terrorism, imprisoned not more than 8 years, or both. But then, in addition to that, Her Honor also finds herself now, by grand jury, indicted with count 2, concealing a person from arrest. That is found in 18 United States Code Section 1071, a statute which reads as follows. Whoever harbors or conceals any person for whose arrest a warrant or process has been issued under the provisions of any law of the United States, so as to prevent his discovery and arrest after notice or knowledge of the fact that a warrant or process has been issued for the apprehension of such person, shall be fined under this title or imprisoned not more than 1 year, or both, except that if the warrant or process issued on a charge of felony or after conviction of such person of any offense, the punishment shall be a fine under this title or imprisonment for not more than 5 years, or both. So despite the fact that we have a lot of people in mainstream media that want to talk about a constitutional crisis, and there very well may be a constitutional crisis, the problem is they're talking about the wrong one. They're talking about renegade judges, those at the district court level that are issuing nationwide injunctions, or those who just simply believe that they are completely above the law and can go out and willfully obstruct law enforcement agencies in the performance of their duty. And this is a classic example now of how the FO decided to FA and is now herself going to have to FO. Listen, we're going to go ahead and link up everything we have about this down in the description box, including the indictment, so you can read it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the info to do that is in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.